From supplemental list, this case item 4 for 367 of 180, along with item 5, 6, 4, and 3.
This is body sheet है ना? पार्टी कमीशन है। किसी कमीशन को चुना पाएगी कि?
नहीं, वो उसमें केस सॉफ्ट मत लीजिएगा।
नहीं पाएगी कोई बात नहीं मतलब नहीं रिकॉर्ड कर।
Then you hide most of arguments, single sources, and the rest of the.
कब आप आएगी?
पूरे चाबी दिए।
ये आपका है? उनको देखिए। देखिए।
First,
पहले यूनियन ऑफ इंडिया कॉपी दिखाइए।
and then they will raise to lawyers from the Supreme Court. They will appear to BC, and tomorrow they are coming physically.
यूनियन ऑफ इंडिया कॉपी दिखाइए। ये तो पार्टी पोजीशन है, ये सिर्फ ऑर्डर शीट है। ये सिर्फ केस का ऑर्डर शीट है। मेमो कॉपी नहीं है। तो करेक्शन वगैरह सब हो चुका है। कोई आगे तो अभी पेंडिंग नहीं है। यस प्लीज।
No loss.
स्टे और आई को हमारे साथ।
हाँ।
Since we assessing
If number 367 of 18 getting.
I'm beginning with my argument because the short notes, but I can find from the file that now the exhibit is with the associate counsel, but I will be arguing in this time. So, I not be listening to the come to the bar. It is at page 11. Please can it starts with this.
एडिशन ऑफ पार्टी का इंटरव्यू एप्लीकेशन है। ये है इसका अलग इसका मेमो कॉपी करना है। अवार्ड तो ये है यहाँ पर पेज 45 में इसका मेमो कॉपी ये हमको एक्सटेंशन ऑफ टाइम यहाँ पर इनका एक आगे है फॉर एडिशन ऑफ पार्टी जो हम लोग का अलाउ हुआ था उसके पहले होना चाहिए मेमो कॉपी। मेमो कॉपी के साथ आपने अवार्ड नहीं फाइल किया ना?
Subsequently, they are So complete.
Okay, we are at the
Yes, we should not is there because I will be referring the president.
give me some background of the case.
Background of the case is that the land was acquired under this acquisition IIP Act in 1971.
The act completed this one.
Acquisition of immovable property at 1950. What happens?
Under which section?
Acquisition was made under section 7.
Under section?
Yes. Section 7.
Section 7.
How to acquire acquisition.
What is the date? Date of acquisition. Notification number.
This I express my difficulty because now the document I was with you. He is having all the exhibits with him. But the exact dates are
It
not.
is after you put the award itself. It's
Award
not
if it is dates, that is the peculiarity. The award goes so vary in its determination that if I just place from the award and separate, it starts with the Supreme Court judgment and then it proceeds that how the compensation was tendered and then how the references is made and how the arbitrator has come. But some in substance merit, niceties, these are some admitted facts that 72 the awards was prepared, compensation was offered, 80% persons had accepted the compensation without objection, that award itself is placed. If I just place the award 3-4 paragraphs,
acquired in the year 1971.
71 sir.
Okay.
In short synopsis manner, everything I will mention.
You have mentioned. Okay, short synopsis. These foundational facts you can have from the short synopsis also. Chronology of event.
These are some Union of India
During Second World War, this was
was
introduced.
recognition, and then finally in 71, 72.
71, 72 was acquired.
That is how this act is also contemplated. If you acquire or you release it. This acquisition made 71, 72 has been done. And compensation was determined. It was offered to the buyers. That comes in the award also. If 4 paragraph here I read from the award matter, this fact will give you. So I just place 4 paragraphs.
Okay.
The background is also taken note of the award.
Which page are you reading?
I am reading table this 2. 3 paragraphs in the
One session. You place that.
Internal
Internal page 2.
Two.
Short synopsis.
Yes, yes.
Okay.
The arbitration proceeding arises out of the order dated 25/9/12, passed by Honorable Supreme Court of India in civil review, civil appeal number 7/52 of 12, rising out of SCP number 2079. So filed by the appellant land users and directing the state government to appoint an arbitrator to decide the lease between the appellants and other tenants, and also in respect of those persons who have lost their lands pursuant to the notification issued by the state government dated 5/6/19. The background. Under the acquisition.
Just a moment. Why this? There was a separate notification
Yes,
dated
that will come.
5/6/93.
Yes, that is 2-3 paragraph valid. This will be valid. Okay. Just this. The background. Under the acquisition and acquisition immovable property act 1952. Herein after referred to as RIAPL, the land is in 1846.99 acres of in 4 villages, Sonu, Lalganj, Kadanda and Bari, all within PS so and so, were requisitioned by case number 6 of 1941, and the same were acquired in the year 71-72 by the Defense Department in India. The competent authority, under the Act, the competent authority is defined. The competent authority made the awards and paid compensation to the extent of 80% to the land users up to the year 1975. The leadership will take note of it. Some of them received it under protest and approached the authorities for appointment of arbitrator. This is 1991. So what I will take a pause, leadership, and I will just say that out of this large chunk of the land users, some of them received under protest and they approved in 1991 for appointment of arbitrator, not to 6.
They approached in 1991.
And that will come carefully after 16 years. As no arbitrator was appointed, the land user moved the Honorable Patna High Court by CWGC 159291, so and so, so and so, and as per the direction issued, he then State of Bihar appointed arbitrator by notification dated 18/12/91 only with regard to the writ petitions, because those who received under protest they approved. Subsequently, the said notification was amended, modifying the notification dated 5/6/93, referring the cases of all 753 land user arbitration. So it proceeds like that first only for the writ petition, then it extended to 750. Then the said notification dated 5/6/93 was challenged by Union of India before Honorable Patna High Court, while CWJC number so and so. During the pendency of the same, the government of Bihar, by notification dated 11/9/93, cancelled the said notification dated 5/6/93 with respect to 753 land users and restricted the same to the writ petitioners of the aforesaid floor writ application. And accordingly, the arbitrator was appointed on 26/11/1993. Ultimately, the said writ petition CWJC was dismissed on 23/11/2007. The said notification dated 18/11/93 was challenged by CWJC number so and so by 20 of the land users representing representative capacity, challenging the said decision of the government to resign the notification dated 5/6/93. This was dismissed by judgment dated 10/1/8 inter alia, holding that the land users had received the compensation long back and did not lodge any protest within the prescribed period, and that the writ petition had no ability to represent others. Neither the writ petition so says land user, that the nature and details of the land and whether all the land users were alike was not mentioned in the writ petition. That all the land users have woken up and claimed a higher compensation only after the issuance of notification dated 5/6/93. That compensation was paid after adopting due process of law under RA-IPA. Against the said judgment, aforesaid, appeal was filed before Honorable Supreme Court while similarly number so and so. The Honorable Supreme Court while order dated so and so, while allowing the appeal filed by the appellant, land users directed the state government to appoint an arbitrator to decide the lease between the appellant and others therein, and also in respect of those persons who have lost their land pursuant to the notification issued by the government dated 5/6/1990.
So it was open to all.
No, now it replaces the Supreme Court order exactly what it has said. Order. You just press this is part of the order.
Where is the entire order?
This is the entire order. 2 pages order is there. So what should the honorable appeals court says? Should I place the entire?
Yes. Because this is the sheet anchor.
Yes. So being agreed by the judgment and order passed by Honorable High Court of Jharkhand and Ranchi also, the appellant are before us in the appeal by special hearing by the impugned judgment and order the High Court has rejected rejected their petition wherein they had sought for a simple and equitable relief of appointment of arbitrator as provided under 8(1) of the Regulation and Regulation of Individual Property. The factual matters of the case reveals that the land of the applicant and similarly situated persons have been requisitioned by central government under the same Act. Thereafter, since an arbitrator was not appointed as required under the Act for deciding the compensation payable to the land users who have lost their land pursuant to the requisition made by the central government, some of the land users had filed a writ petition before the High Court. Inter alia requesting the High Court to direct the respondent to appoint an arbitrator to decide the claim for a reasonable compensation for having lost their land. The High Court, considering the plea of the petitioner, therein had in fact directed the respondent to appoint the arbitrator to consider the claim of the petitioner in the said petition. Since similarly situated persons had opposed the state government to issue appropriate notification reviewing the matters before the arbitrator, the state government by issuing a notification which is 5693 had referred all the cases of the person notified under the notification for the adjudication of the claim for compensation by an arbitrator. Subsequently, the said notification came to be withdrawn for the reason it is known to them below. Induced by the action of the state, the government, the petition went before the High Court in the petition number so and so. The High Court, in our opinion, very strictly has received the petition filed by the petition. This is how the appellant, inter alia, claiming that they have filed this appeal in the representative tribunal and before us in this appeal. We are also and so, in our opinion, it may not be necessary to go into the detail of the case since we are considering that the High Court was not justified in making a reasonable request made by the petitioner in the petition. At this stage, we also take note of the fact that persons who have lost their land because of the requisition in approval indicates regularity. In a matter of this nature, in our opinion, the good conscience should have prevailed on the respondent to have accepted the reasonable request made by the appellant instead of arguing the matter on technicality. In view of the above, while allowing this appeal, we restore the order of notification issued by the state government so and so. We are informed that arbitrator appointed under the present constitution is removed. Therefore, we direct the state government to appoint a new arbitrator to decide the lease between the appellants and others, and also in respect to those persons who have lost their land pursuant to the notification issued by the state government. Make it so and so as expeditiously as possible at any rate within time frame within a month's time from the date of receipt of the order. We further request that the arbitrator who will be nominated appointed by the state government to decide the lease between the parties as expeditiously as possible in view of the fact that the registry on this land was done by the central government way back in 1973. We clarified that. This two lines will be important. We clarify that we have not expressed an opinion on the merits and demerits of the case of the parties to the lease. Now, before I proceed with the further paragraph of the award, one judgment, because two facts have been noted by the arbitrator, that everybody accepted it except for some. Para 3,
so ultimately, the notification dated 5/6/93 prevailed.
Prevailed so far as
It
appointment
was open to all.
Open to all, but merit of the case, because we have right to object, we file our objections before that. Our case was that those who received in 1975 without protest will not have any case number one. Those who have received under protest, they have come before the arbitrator. Their case.
So basically, you want to simply non-suit those persons who have not raised their grievance against them.
Yeah.
What is the big idea of this notification dated 5/6/93?
Only
Otherwise also
to provide a
forum for what?
Arbitration for
A person who has not raised his grievance, raise the question of any adjudication.
So that is how it has fallen that these will be decided between the parties. So our case is that, for you, definitely for my thoughts and consideration, our case is that the arbitrator was ought to have taken note of the fact that those persons who have received the protest, what will be their locus. Then those who have received with protest, what will be their locus and to what extent compensation. And then what is the mechanism adopted by the arbitrator in determining the compensation. This is the broad contours of my argument. Because ultimately, and whether the solution which is not provided under the Act, whether it
That
will
will
be
come
like
later. That will come later.
That
So
will
your
come.
first submission is that those persons who never received the amount under protest, they should be simply they should have been simply non-suited by the learned arbitrator.
Yes, that is right. For them it was non-suited, and this fact whether I am relying on the judgment of the apex court in the case of 1996 766 715. This pertains to when an application and application act itself. It's a short judgment.
Para 5.
Para 5 will be relevant for us. The controversy raised in these cases is squarely covered by the judgment of Union of India versus Bhusha. Following the judgment, we are constrained to vote versus no action has been taken by the claimant in communicating the objection for not accepting the award within the time prescribed under the law. It must be deemed that they have accepted the award. Consequently, omission to appoint arbitrator under 81B of the Revision and Revision Act, read with Rule 91 of the rules made under the Act is not vitiated by an error of law. The High Court therefore was right in directing that the impugned judgment of order of appointment of an arbitrator. Directing in the impugned judgment appointment.
Right. So the point is that this court, this judgment says that there is no need for appointment of arbitrator. A person who has
For
accepted
20
the award
Yes.
without any protest,
Yes.
without any particular objection.
Yes.
So there is no question of.
So it is not so. That is my case, right? Because now they say that this 20% approach Supreme Court that we are representative capacity. Honorable Apex Court says that very well you go, you satisfy the arbitrator if you do have case. So, but we have not gone into the merits and demerits of the case. So this issue is open for evaluation. Because ultimately the state exchequer is.
Did you put before the learned arbitrator
Yes.
as to how many persons have taken it as a protest?
That is the